Apologies right from the start. Even though I'm using PowerPoint, it is not a PowerPoint presentation. I'm only using this platform to present my presentation. Unfortunately, I was caught unawares that the conference is going ahead and I didn't have time to compile a PowerPoint presentation. But without further ado, let's go ahead. My talk is on the effect of the admission of guilt, of an admission of guilt and payment of a fine in terms of Section 57 of the Criminal Procedure Act. And it concerns a case that was decided in 2019 in South Africa. What is the background to the case? In this case, the applicant applied for an order to set aside a conviction and sentence incurred in terms of Section 57 of the Criminal Procedure Act 51 of 1977. Now, let's first have a look at what the section says. It provides that an accused may, where a summons or a written notice is endorsed to the effect that an accused may admit guilt to the offence and pay a fine, admit his guilt in respect of the offence and pay the stipulated fine without appearing in court. One of the essential particulars of such admission of guilt and payment of the fine had been entered into the applicable criminal record book. The accused shall be deemed to have been convicted and sentenced by the relevant court in respect of the offence in question. Now, this is a similar provision that I would think you find in most countries, where somebody can pay, admit to an offence and pay a fine without going to court, and it is mostly used for lesser offences, traffic fines, even common law offences, but which are not so sincere. For example, assault, common, etc. The reason behind this, of course, is that there is just not the capacity to take all these cases to court, and the system will grind to a halt. All right, now let's look at the events in this case leading up to the application by the accused to have his admission of guilt and payment of a fine set aside. That happened a few years earlier. All right, the applicant in this case was arrested on a complaint of common assault. The case was processed, including it being entered into the SAPS registers, fingerprints being taken, and a docket opened. While the applicant was being detained, he was handed a written notice with an endorsement that he may admit guilt in respect of the offence and that he may pay a fine without appearing in court. The accused paid the fine and was released. Subsequently, the particulars were entered into the criminal record book at the relevant magistrate's court. The magistrate examined the documents as it is required in terms of Section 57, subsection 7, and the details were entered into the SAPS criminal record system. But what happened after this? Some 7 to 8 years later, the applicant applied for a job that required a police clearance certificate, and in the process of acquiring a clearance certificate, the applicant became aware that he had a criminal record. He was informed that the admission and payment of a fine all those years earlier was by law a conviction and a sentence. The applicant applied for an order to have his conviction and sentence set aside, and the matter came to be heard by the High Court. Now, what were the grounds of review that were raised by the applicant? 1. His conviction and sentence was not in accordance with justice. 2. He believed that the only option to be released from custody was to pay the fine immediately, and accordingly the payment was not made freely and voluntarily. 3. His actions in paying a fine in order to secure his release from custody was reasonable. 4. He was not properly informed of his rights, nor were his rights explained to him at any stage, which was in violation of his constitutional rights in terms of Section 35 of the Constitution. So what he basically said is he paid to get out of custody, and he didn't know it was a previous offence, and this is an injustice. What did the court decide? The court already early on in the judgment already expressed doubt that a conviction referred to in Section 57 was a conviction envisaged in Section 271 of the Act. Now, Section 271 of our Act provides for previous convictions and that previous convictions may be proved. As a consequence, the court also doubted that a conviction in terms of Section 57 was to be entered into the criminal record of a person at the Criminal Record Centre of the South African Police Services. The court held that a written notice as a means of securing the attendance of an accused in court was meant for less serious offences in the Magistrates Court, that is the lowest court, criminal court under South African law, and that such a notice could only be issued where the peace officer reasonably believed that the Magistrates Court could not impose a fine exceeding the amount determined from time to time by the Minister in the Government Gazette. The peace officer could in such instance endorse the notice that the accused could admit guilt and pay the fine without appearing in court. The court also indicated that generally where a fine as a nature of punishment could be imposed on a person convicted of an offence, which fine was determined without a punishment alternative to such a fine, it was considered for trivial offences only. The court added that the fine that the Magistrates Court could impose was 120,000 rand. Of course, if it's not otherwise provided for, and that the amounts determined for a written notice and the summons in section 56 and 57 were 10,000 rand. 10,000 rand represented 8.33% of the limit of jurisdiction for a fine which a district court may ordinarily oppose, and that fine was markedly lower as when somebody would be convicted in court, and it was indeed for very trivial offences. The court also indicated that sections 57 subsection 6 and subsection 7, the admission of guilt fine was paid at the police station or local authority, and the relevant notice had to be forwarded to the relevant clerk of the Magistrates Court, who had to enter the essential particulars into the criminal record book. Subject to subsection 7, the accused would be deemed to have been convicted and sentenced by the court. The court confirmed that the relevant judicial officer had to examine the documents, and if it appeared that the conviction or sentence was not in accordance with justice, or the determination made by the relevant magistrate, or where the determination was not made that the sentence was not adequate, he or she could set aside the conviction and sentence. The judicial officer could also, in lieu of setting aside the conviction and sentence, direct that any amount paid in excess of a determination by the magistrate be refunded to the accused, and this is in terms of section 57 subsection 7. The court accordingly held that a conviction and sentence in terms of sections 57 subsection 6 was sui generis. It was not a verdict and not even a pronouncement by the clerk of the court. It was an automatic consequence of an administrative act performed by a member of the support services. The facts of the case and whether the accused admitted or denied some of them, and whether the accused was guilty in law, were not considered at all in the conviction. The clerk of the court simply entered what was essentially an agreement between the state and the accused on the court records. The trivial dispute was set out in the written notice with an endorsement that the accused may admit guilt. The state agreed not to pursue the trivial dispute in exchange for the agreed payment. It was therefore a documented waiver of the dispute which the state had against an accused upon payment of a stipulated amount. It was a waiver by the accused of his right to have his case proved beyond a reasonable doubt. In the settlement, the strength of the cases on either side is never tested, and the accused is not required to set out the facts which he admits and on which the admission of guilt is based. The section does not envisage an unequivocal admission of guilt. The admission of guilt is not one envisaged in section 217 of the Act. The nature of the oversight in terms of section 57.7 was to detect problems with regard to the documents. Clearly, the magistrate could not provide oversight with regard to the facts of the case. It was not a decision on the facts of the case, and the magistrate could not pronounce that evidence proved the commission of an offence. The magistrate did not find the accused guilty and did not sentence him. After this, the court proceeded to discuss authorities with regard to a conviction envisaged in Section 271 of the Act, and based on this, the court found that a conviction in terms of Section 57 was not a previous conviction unless the offender was brought to court, found guilty beyond a reasonable doubt based on all the evidence, and convicted and sentenced for the offence. The court also held that the only competent authority to make a pronouncement with such dire consequences should be a judicial authority. A conviction referred to in Section 57(6) is not such an authority. The court also referred to the differences in the process to explain the differences between a conviction in terms of Section 57(6) and a conviction in terms of Section 271 of the Act. The court held that the court should not inquire into the merits of the case and that the accused ought to be entitled to relief if he paid the admission of guilt without knowing that he would receive a criminal record and if he wished to defend himself. In summary, and for the reasons stated, the court found that the conviction of the accused in terms of Section 57 was not a conviction as envisaged in Section 271 of the Criminal Procedure Act. The court further held that a conviction and sentence following an entry into the admission of guilt record book by the clerk of the criminal court was not a record that was permanent. It was furthermore not a conviction and sentence to be entered into the criminal record system by the South African Police Services. The court accordingly set aside the conviction and sentence. All right, what can we say about this? The first issue is whether a conviction in terms of Section 57 subsection 6 was not a conviction envisaged in Section 271 of the Criminal Procedure Act. Right from the start, I must first point out that this decision is at odds with another decision of higher ranking where the Court of Appeal held that an admission of guilt in terms of the previous Criminal Procedure Act could be proved as a previous conviction against an accused, therefore directly contrary to what the court here decided. Section 57 subsection 6 furthermore specifically and clearly provides that where a fine is paid in terms of the provision and entered into the criminal record book, the accused shall, subject to the provisions of subsection 7, be deemed to have been convicted and sentenced by the court with respect of the offence in question. There is additionally no doubt that if the court convicts an accused, it is a conviction envisaged by Section 271. It follows that if a conviction in terms of Section 57 subsection 6 is deemed to be a conviction by the court, and a conviction by the court is a conviction for purposes of Section 271, then a conviction in terms of Section 57 subsection 6 is a conviction for purposes of Section 271. It is difficult to see how the court could have come to a different conclusion. All right. It is also noted that the term conviction is not defined in the Criminal Procedure Act. However, the South African Concise Oxford Dictionary confirms that the term refers to an instance of being convicted of a criminal offence. Whether an accused was convicted by a formal hearing, or whether an accused was convicted by his agreement to be convicted by his payment of a fine, or whether he was convicted out of his own mouth by admitting guilt, the result is the same. The accused was convicted of a criminal offence. It is furthermore submitted that there is nothing in the Criminal Procedure Act or otherwise to suggest that a special or technical meaning was intended by the legislature for the term conviction in Section 57 subsection 6. There is therefore no reason to interpret the term in Section 57 subsection 6 any different than in accordance with the ordinary grammatical meaning of the word. Moreover, the South African system of criminal justice does not, as a matter of principle or policy, provide for different types of or levels of conviction. One is convicted or deemed to have been convicted of prohibited conduct constituting an offence or not. Of course, offences differ markedly in how serious they are, and there are varying levels of guilt involved, but it is the function of the sentencing process and/or considerations to provide for the punishment of each offender. It is also the prerogative of the legislature to decide if a certain category of offenders are to be treated differently, as was done by the legislature by way of Section 341 of the Criminal Procedure Act. And just by way of explanation, Section 341 is a specific section in the Criminal Procedure Act which is meant for municipal offences mostly, where the Act specifically says that you pay the fine in order not to be prosecuted. This is not the same with regard to the written notice and the summons that we are talking about here, where it does not say that. It specifically says otherwise, that if you admit your guilt and if you pay the fine, then you are guilty of an offence. Alright, in terms of Section 341, an offender is allowed to pay a fine with respect to certain minor offences, whereupon the offender will not be prosecuted for the offence, as I have explained just now. No such or similar provision was made by the legislature with regard to prosecutions provided for in terms of Section 57. The fact that Section 57, subsection 6, provides for a specific sui generis procedure does also not change the position and does not bring about that a conviction in terms of Section 57.6 is not a conviction for purposes of Section 271. I correspondingly submit that the court was misguided in its deliberations and findings in this regard. The court furthermore committed a series of errors in coming to its conclusion that a conviction in terms of Section 57 did not amount to a conviction for purposes of Section 271. There is also no doubt that these findings were incorrect. Admissions of guilt resulting in a conviction in lieu of the accused having to appear in court have long since been a proper element in the South African criminal law enforcement system. It is furthermore safe to postulate without this element, the criminal justice system would not be able to cope with the volume of prosecutions. This element is therefore essential to society's compelling interest in convicting and punishing those who commit less serious offences. It is furthermore accepted that the Constitution, South African Constitution, including the right to remain silent and the right against self-incrimination, do not prohibit an accused to waive his rights, agree to pay an admission or guilt fine, and have a conviction noted against his name instead of going to court. Far from being prohibited by the Constitution, an admission of guilt fine, if the safeguards are met, are most probably also desirable to the wrongdoer, as it relieves the wrongdoer of the burden of going to court. The administrative differences referred to are furthermore of no significance. The differences are merely the result of the different routes which led to the conviction and sentence and common law considerations and common sense considerations. Pragmatism and convenience furthermore dictates that the convictions for purposes of Section 57 subsection 6 and the convictions with regard to every court be kept separate for future reference as part of a case management system. I conclude. The court erred in finding that a conviction in terms of Section 57.6 was not a conviction envisaged in Section 271 of the Criminal Procedure Act and should accordingly not have been entered into the SAPS criminal record system. It is also not agreed with the court that a review court should not inquire into the merits of the case, and that an accused ought to be entitled to relief if he paid the admission of guilt fine without knowing that he would receive a criminal record, and if he wished to defend himself in court. What is required to intervene is a probable failure of justice. This alone does not point to a probable failure of justice. The court must additionally be convinced that the accused admission of guilt was probably incorrect or mistaken, and if the accused went to court, he would have a probable or arguable defense to the case. I thank you.